We don't, I don't understand those things.
We got a lot of people in the hallway. You go next door, please, sit anybody over there, and sit the audio over there, just in case someone wants to sit over there.
Where's the door?
Welcome everybody to the Small Business Insurance and Industry Committee. We're going to begin as a subcommittee, and we're going to hear Senate Bill 745. Senator Romine, you may proceed.
Thank you, Mr. Chairman, members of the committee. Senator Gary Romine here, representing the 3rd Senatorial District, here to present to you Senate Bill 745, the Employment Discrimination Bill. The main goal of the bill is to raise the standard from contributing factor to motivating factor. As we look at economic development in the state, one of the key issues that we have to deal with is the concern of litigation and the frivolous lawsuits that's brought a lot of small businesses in the area. This bill will go a long ways to establishing more firm standards for discrimination. We see a lot of times, we have seen several occasions where the Commission on Human Rights has determined no merit in a case. In their infinite wisdom, by rule, I guess they're sending out a right to sue letter, and because the contributing factor is a standard, even a small crease creates an opportunity for that plaintiff to file another claim. All that you went through in the Commission on Human Rights is non-discoverable. You cannot use any of that process in the next phase. Very frustrating as a small business owner to have to deal with this type of environment. And Mr. Chairman, I'll be happy to answer any questions, but would like to see this bill proceed and go forward.
Okay, thank you, Senator. Any questions of the bill for Senator? See none, you have anyone you'd like to call forward?
I have no formal list,
Okay.
I just call it as you see.
Okay. Anyone in support? Yes. Anyone in support? Anyone in support of Senate Bill 745, please come forward. Introduce yourself and make.
Thank you, Mr. Chairman. Members of the committee, Ray McCarty, President of Associated Industries of Missouri. And this bill really aligns our Missouri law with the Federal Human Rights Act in terms of what the standard is to determine whether someone's liable for discrimination charges or not. The low contributing factor is so low that if someone's in a protected class, the burden of proof really shifts over to the employer to prove that had absolutely nothing to do with their decision that they've made that's being challenged. And that's a very high standard for an employer to have to try to prove. In fact, it's almost impossible. So we are very supportive of taking this back the way it has been until the courts have changed it recently. It's always been a motivating factor until recently when the courts have decided to observe a very low standard of contributing factors. So this would make us use the same that's used in the Federal Human Rights Act, and we're very supportive of that. And to save time, Mr. Chairman, I have a witness form for David Overfell from the Retailers and Grocers Associations. Both of them also in support. Be happy to answer any questions.
Okay, thank you. Any questions this witness? Seeing none, thank you very much. You did fill out your witness form, I'm sure. So, reminder to everyone who comes in to testify, you do have to fill out a witness form, which is conveniently located at the desk you'll be testifying from, and you can just leave it there on the desk somewhere, and we will gather those up when this hearing on this particular bill is over. Thank you. You may introduce yourself, continue.
Thank you, Mr. Chairman, members of the committee. Brian Bunn, General Counsel for the Missouri Chamber of Commerce and Industry. I'd like to go on record in support of the bill for the same reasons you just heard before. I would like to see the standard raised from the contributing standard to the motivating standard. This bill also allows for summary judgment in these instances. We'd like to see an elimination of that individual liability that's in the existing statute, and we'd like to see a placement of reasonable and meaningful caps on damages in these instances. All we're asking you to do is to align with the federal standard in the majority of other states. The Missouri Chamber of Commerce Civil Justice Policy Council has identified this as our #1 priority, as it has for years prior. This is about the 9th iteration of this bill. With that, I'll be happy to take any questions.
Okay, thank you very much. Quick announcement, anyone gets tired of standing, you can go next door over here. You have audio, you do not have video, but you will be able to hear everything we're talking about. And also, if you decide you'd like to testify at that time, we will wait on you. Just don't tarry very long getting over here. All right, thank you very much. Any questions? Seeing none, thank you very much. Thank you very much for your testimony. Be sure you fill out your witness form. How many is here in support and wants to testify today on this bill? Raise your hand. 2. Did I see another hand back there in the back? Only 1 in support? 2. Okay, how many is in opposition? About the same. So we'll just continue like we're doing. Introduce yourself and make it clear.
Senator, thank you. Austin Walker, Manager of Government Relations for the St. Louis Regional Chamber. We serve as the Chamber of Commerce and Economic Development Organization for the St. Louis Metro region. The St. Louis Regional Chamber supports policies that will strengthen the region's business climate by ensuring employers and workers are provided a just, efficient, and consistent legal system. We're committed to attracting and retaining a highly skilled and diverse workforce and fostering inclusive business communities. Therefore, the Chamber supports employment law reforms such as those in Senate Bill 745 to achieve fairness and consistency that better protects employees and employers in conjunction with adding sexual orientation and gender identity to the list of protected classes in Missouri law. A series of court decisions over the past decade has eroded the intent of Missouri's employment law, tipping the scales against employers. And a key concern stems from Missouri's employment law using a low standard for deciding a case under Missouri Human Rights Act. Current law makes it difficult for meritless cases to be dismissed and set the standard of proof extremely low for discrimination cases. The increased number of lawsuits and likelihood of going to trial results in a higher cost for businesses, both from expensive settlements and costly time-consuming litigation. By changing the Missouri employment discrimination language to bring it in line with federal standards, SB 745 takes steps to remedy this situation. For several years, the St. Louis Regional Chamber has supported reforms to strengthen and restore balance in the state's employment laws. A strong employment law reform bill will keep significant protections for employees, provide employers clarity regarding potential liabilities, and help avoid meritless litigation, and improve Missouri's ability to attract new employers and grow existing business. I urge the committee to pass Senate Bill 745 without delay. I appreciate your time and answer questions.
Questions or witnesses? Seeing none, thank you for your testimony.
Mr. Chairman, Brad Jones.
Hang on just a second, Brad. Let me do roll call real quick. Right there, please.
Senators Parson. Here. Liblow.
Here.
Munzinger.
Here.
Wallingford. Here. Watson. Whelan.
Here.
Pearls.
Here.
And Paul.
Quorum is established.
Once again, Brad Jones with the NFIB, and we would register and support this bill. We've supported this bill for been around for a long time.
Thank you. Questions or witnesses? Seeing none. Anyone else? And we are on support.
We're on support. I may have people in the other room. I'm not going to give this comment. Anybody else in support?
Anyone want to testify on this bill? If you are in the overflow room, if you'll make your way to this room. And for much as we can, we're trying to keep the doors a little clear where people can get in and out. We can do that. Maybe if you need to, you can step up front, even up here a little further. I'm okay with that better than I am. The doors. Okay. Support. Senate Bill 745. Support. Seeing none. Opposition. Opposition. Senate Bill. Who else is in opposition in there? Okay. 3 of you? 4? 4. Okay. Yeah, people in opposition, if you come on in, probably, and if you let everybody in the doorways, make sure people get here to testify. State your name and record. I need everybody to remind everybody to call a witness sheet. And we're ready to move on.
Mr. Chair, Senators, I'm Eric Kriegel with the Missouri Commission on Human Rights. And the Commission would like to testify against Senate Bill 745 because of its concern that we could lose the federal funding that we receive from the Equal Employment Opportunity Commission and the Department of Housing and Urban Development. That federal funds, those federal monies fund about 62% of our staff. So that's very important in terms of the staffing of the commission. We're able to contract with EEOC and HUD because they have determined that the Missouri Human Rights Act is substantially equivalent with the federal civil rights laws. And they have concerns that So the provisions in Senate Bill 745 would not be consistent with federal law. I have letters from EEOC and HUD that I have attached to my witness form. So with that, are there any questions?
Questions of the witness? Senator Wallace.
You need to educate me on this because I'm a little confused. We just had a couple of witnesses say this will align us with the federal standard. And now we're saying if we align with the federal standard, we're going to lose federal funding. Can you talk about that?
Yes, sir. Some of the provisions in Senate Bill 745, according to HUD and EEOC, would not be consistent with the federal civil rights laws that they enforce. For instance, EEOC has a problem with the provision in Senate Bill 745 that says you will use the analysis in the Price Waterhouse decision, the same decision test in the Price Waterhouse case. EEOC has a problem with that because 2 years after the Supreme Court passed the Price Waterhouse decision, Congress overruled it when it passed the Civil Rights Restoration Act of 1991. Both EEOC and HUD have a concern with defining discriminate or discrimination as to motivate, or the motivating factor is one of the protected categories, because that would preclude areas that they cover that are fair in form but discriminatory in effect. That's known as the disparate or adverse impact analysis and discrimination claims, where statistics can be used to prove discrimination. HUD also has a concern that Senate Bill 745 exempts the state or its political or civil subdivisions from punitive damages when it discriminates, because HUD believes that punitive damages, or the possibility for punitive damages, are an essential part of the enforcement scheme.
Okay, I'm trying to connect the dots here. So apparently we had the motivating factor previously. I didn't hear a year, but previously, and then the courts kind of ruled from the bench, and then we went to contributing factor. So we're saying we didn't have HUD funding when we had this rule before, and other states that have motivating factor don't get HUD funding.
We did get HUD and EEOC funding prior to that court decision.
Okay, thank you.
Yes, sir.
Further questions of the witness? Seeing none, thank you. Next, in opposition.
I'm Nimrod Chappell, the president of the Missouri State NAACP. It's a pleasure to be with you today. I have to tell you that this legislation, this proposed legislation, is far-reaching, and I think that it's long overdue in one respect. It's high time that we recognize that Missourians are being discriminated against on the basis of their sexual preference, whether it's gay, lesbian, bisexual, transgender, or what have you. Those people need protection. However, I don't think that the Constitution, that our good conscience, that for most of us our faith, would allow us to water down another person's civil rights in order to gain those protections. It's a false trade. You can't extend coverage to another group of people by reducing what we would do for other folks. There are seniors who are with us. There are folks who are disabled of all ages. Half of our population at least has got to be female. A large portion of Missouri is one color or another, one hue of brown. All those people deserve the protections that are currently allowed for in the Missouri Human Rights Act. To allow this piece of legislation in particular to go forward, to say to people that there is a limit for damages that you can cause by discrimination, right? Insults, that's one thing. If you don't allow someone to work, that's another. If they're a highly compensated individual, that's even another. If you assault someone, you touch a person inappropriately on the basis of a protected category, you would essentially be saying that it's okay and that we're going to put a dollar amount on what that can be. I don't think that that's just, nor do I believe that it's moral. Another issue that we have to face is the contributing factor, right? Missouri, as America, is a land of laws. We have nothing else if we don't have the laws. But here we would like to take the issue away from a jury who ultimately gets to decide, is what happened in a particular circumstance enough? Does that rise to a level, A, that the party is going to prevail in the first place, which is rare, I'll tell you. I understand that there are groups here, and I'll be eager to get a list of those folks, the Missouri Chamber, the folks out of St. Louis, and any other businesses who are supporting this legislation, because I think that it's important that people know that there are folks out there that would like to take away the jury's ability to function. And we don't need that. Changing the standard is only geared to do one thing, to make it harder to win these cases, right? And if you don't want to have discrimination laws, then maybe you do another version of this and you just take them off the books. Maybe you make it like liability. For example, if you get hit by a car, right? You don't have to ask permission to sue. There's no investigation. You go file your case in court. I think that if you want to do that, that's a different solution, one that merits discussion. But to come here today and say that the tough discrimination cases that are already having to be fought in Missouri, and they're being fought from east to west. We already have the trouble in St. Louis. We have the trouble at Mizzou. And I'll be frank with you, as a civil rights leader in the state, I can see several other issues that are just bubbling and waiting. I'm tired of Missouri being on the forefront of the news, not for innovation, not for being good stewards, but for mismanagement up and down, whether it's at the local level, the state level, or even of federal monies that are entitled and trusted to us, which we just heard about. To say that this goes back to the federal standard is just a farce. The federal standard was adopted after Missouri adopted its standard. We came first. We set the road, and I think that that's what we Missourians want to have. The provisions entitled are brought forward in this legislation really create another kind of citizenship. You know, and you've probably heard me say it before, but I'll say it again. Missouri is not a Jim Crow state, and I don't think that we want to go back there. That's what this kind of legislation is geared to do. To say that some injuries to some individuals are worth less, putting a cap on them, or that they have to be reviewed in some entirely different way. I'm an American. I've got rights just like everybody else, and so do my kids and your moms, your sisters, and your families. Passing this legislation disenfranchises people from their civil rights. I would strongly urge you not to do it.
Questions of the witness? Seeing none, thank you for your testimony. Next, in opposition.
My name is Christy Kingston. It's a pleasure to be here speaking today on this bill. It was important for me to come down today to talk to you about this law because I think one thing that hasn't really been addressed today are some of the problems in the language as this bill is written, and I want to kind of go through those. First of all, I'll tell you a little bit about myself. I'm an employment lawyer. I'm here speaking on behalf of the Missouri Association of Trial Attorneys. I've been representing plaintiffs in discrimination cases for about 18 years. And during that time, I would like to tell you that the business that the calls that I get, the people calling for representation, that number has just decreased, but it hasn't. And because there's still discrimination happening in the workplace, it's important that we have a strong state law that prohibits and protects employees from being discriminated in the workplace. And that's what we have right now with the Missouri Human Rights Act. The act, as it's in existence right now, is not broken. This bill proposes to make changes to something that's currently working and operating just fine and has some of the strongest protections of any state in the country to stop discrimination from happening in the workplace. And personally, I think that's a really good thing and something Missouri should be proud of. And this bill takes away the strength of that bill. Now, I'd like to talk specifically about how that occurs. First of all, there's been some discussion that we should change the contributing factor standard to a motivating factor standard. My first question is, why? If an employer is treating an employee differently because of their race, their sex, their age, and that plays a part or is a contributing factor to the decision to take adverse action against that employee, i.e. to terminate them, to demote them, to cut their pay, then we should act and have protections available for those employees. We shouldn't only allow employees to be protected if the primary reason that the company is treating them differently as their race. Why does it have to be the primary reason? I think if race is a part of the employer's decision to treat them unlawfully, that should be enough. And that's why contributing factor is a great standard for us to have and one for us to keep. Additionally, I'm hearing testimony that it tips the scales in favor of the employer. First of all, I've heard no evidence that that's the case. That may be a perception, but I don't think it's true. I think as you look at the number of discrimination cases actually going to trial or being tried in front of juries, you're seeing wins and losses for those clients. It's a balanced system in place with the contributing factor standard we have. And I guess the cynical part of me wants to say, so if the scales are tipped, I'm not agreeing that they are, but if they are tipped, why is it a bad thing to tip it towards protecting an employee from discrimination? I mean, it is a societal goal and an important goal that we should all be striving for to keep our employees in the state of Missouri from being sexually harassed in the workplace, from being treated differently because of their race, by being fired because of their age, for being demoted or paid less because of their religious beliefs. Those are important societal goals that we need to keep in place. Additionally, this bill changes the law as it exists now. Right now, under the Missouri Act, you can sue an individual for sexually harassing you, for discriminating against you. And if we go back and adopt all of the federal laws that this bill wants us to adopt, we are taking away the ability for those individuals to be held accountable and responsible for their actions. I would think companies would like that, because if I'm a company and my company is being sued and I'm arguing the case before the jury, I would like to be able to tell the jury, look, this employee should be held accountable for the actions too, not just us as the company, as their employer. And so I think keeping individual responsibility and individual liability is an important thing, and this bill takes that away. Additionally, this bill creates exceptions, and I'm not really sure why. One of the exceptions it creates is private membership clubs are exempt. Why? If you are an employee working at a private membership club, why should you be allowed to be subjected to sexual harassment or race discrimination in the workplace? It doesn't make any sense, and I think that's another reason that this bill should be rejected. Additionally, it changes the punitive damage caps that are in place right now under the Missouri Act. And I understand the idea that companies want to have caps in place that keep, this idea of jury verdicts, runaway jury verdicts that we hear about in the media. I don't really think there are such things as runaway jury verdicts. I think jurors are very capable of assessing and deciding the value of cases on their own, and I think we should respect the jury system. But what I want to remind this committee is that these caps that are being proposed in this bill are 25-year-old caps that are in place under federal law. We have punitive damage caps already in Missouri. They are limited to 5 times the actual damage award, or $500,000. So there's no concern that we're going to be having runaway verdicts as a result of this. And lastly, I just want to talk about the last part of the bill that nobody really touched about, and that's the whistleblower protection. The very end of this bill goes in, and right now, it's illegal to be wrongfully terminated in the state of Missouri for filing a work comp claim, for reporting illegal activity that your company is engaging in, for serving on a jury. Those are things that are all protected under Missouri common law. What this bill does is it attempts to codify or put into writing the protections for those who report illegal activity in the workplace. The problem with what they put in this bill is that what has been codified, what has been reduced to writing, is worse than what we have in place now under Missouri common law. And once again, I go back to the idea, if it's not broken, why fix it? One of the problems with this bill in the language is that it doesn't allow for protections for employees who report what they believe in good faith to be illegal activity. That in good faith language is missing from this bill, and I think that's a real concern. Additionally, the way that this bill is written, it carves out exceptions for certain groups of people who would be reporting illegal activity in the workplace, and doesn't afford them or allow them any protections, and I think that's a concern as well. For instance, it says you're not a protected person if you're not a manager or a supervisor. Really? Why? If I'm an administrative assistant or I'm a secretary and I see that my company is dumping toxic waste in a river and I go report that and I get fired, that was the right thing for me to do, to report that my company that I was working for was engaging in illegal activity. And under this bill, I'm afforded no protections because I'm not a manager or a supervisor. It's problems like this that is the reason I'm here speaking, and I'm encouraging you, please, to reject this bill keep in place what we have now under the Missouri Human Rights Act and what we have in place with Missouri common law to protect whistleblowers. There's nothing wrong with those systems that we have. They're working, and Missouri should be proud of the strong laws it has on discrimination. Thank you.
All right, questions of the witness? Seeing none, thank you for your testimony. Next in opposition.
Mr. Chairman, members of the committee, Otto Page on behalf of Missouri NEA. We do wish to go on record in opposition to Senate Bill 745. Feeling a little sentimental because this is the 10-year anniversary. Kudos to the Senate staff for maintaining such a detailed history of the legislative history on the Senate summary. And so for those reasons and the excellent testimony that just preceded mine, I'm not going to go into a lot of details about the particulars of the bill. We do believe and have continued, since this bill hasn't changed much over 10 years, that it will make it harder for employees to hold their employers accountable for improper acts of discrimination, which we think should be unlawful and for which they should be held accountable. We also have the concern about the impact on the whistleblower law. And my folks, as public employees, are often that first frontline defense against concerns that need to be raised about the actions of public officials. Sometimes they're the first ones to know about these problems, be able in a position to report that. But I think the one remaining comment I want to make is this issue. I think we're sensitive to the sponsor's concern that there is a very delicate balance and that this is a challenging area of law to legislate in. Our concern is this bill is not evolving. I testified against this same exact bill 10 years ago, which is why I'm not going to take up a whole lot of time on the details. But it looks to us more like it still remains kind of a comprehensive wish list of kind of one side of that dialogue. And we would like to see there be some realistic discussion about how do you narrowly tailor anything that is needed. We have yet to see a very compelling case that there are egregious provisions that need to be changed, but we're open to learning more about that and seeing if there are particulars. But the provisions here, motivating factor, the burden of proof, exempting the agents, direction of the court, damage caps, they don't seem to be the right response to this situation. It seems to be kind of just one side's wish list. We think that this committee should not move forward with developing standards. Happy to answer any questions.
For your testimony, any questions?
Thank you so much.
Seeing none, thank you. Anyone else opposition? Opposition.
Mr. Chairman, Greg Porter, registered lobbyist on behalf of the ACLU Missouri Net. ACLU would just like to go on record in opposition to the bill.
Thank you. Any questions of the witness? Seeing none, thank you. You want opposition?
Hello, my name is Rachel Greathouse. I'm with Empower Missouri. I'm a legislative intern, and we just wanted to go on record in opposition of 745.
Who are you representing?
Empower Missouri, an advocacy agency.
All right. Thank you. Any questions of the witness? Seeing none, thank you. Anyone else opposition? Anyone in opposition? You want for informational purposes only. That concludes the hearing.
Mr. Chairman, may I just make a closing comment?
You may.
I just want to say that discrimination on any level in any environment is wrong. We need to abolish discrimination any way we can. But we also have to look at the business industry. And being in business for 28 years, seeing my peers and myself subject to frivolous lawsuits because of this type of contributing factor instead of truly being a factor in the issue is great, costing the businesses to have to incur a lot of expense, not only in litigation, but employment liability practice, insurance, so on and so forth. So this bill does need to be addressed in this General Assembly, and I appreciate the opportunity.
All right, thank you, Senator. That concludes the hearing on Senate Bill 745. Senator, you're up again. Senator, next up is Senate Bill 746. Before you get started on that, last year, I made an exception in this committee to allow the media to come in here and film in this committee. First of all, I had a policy, I wasn't going to allow that. It's been long-standing, and I decided last year that I would allow that in this committee, and I continue to do that. But I will say this to some of the media outlet: if I ever receive a letter telling me what you're going to do or demanding you're going to film this committee without asking for permission, I will assure you that will not happen again. So you know who wrote the letter. I'm going to tell you there's a right way to conduct yourselves when you want to ask permission to film this committee, and that's the way it will be, and I will allow that. But again, the rules of the Senate are pretty clear. The lower court has decided on this issue, that if you want to record in here or you want to film, you will request permission and you will obtain permission to do just that. So far, we've allowed that. Last thing I need is receiving some letter like I received this week about recording in here. And I might add to the people that wonder what the heck the committee man's talking about, I did allow them to do that even after I received such a letter. So again, Senator, we're ready for your bill.
Thank you, Mr. Chairman. Members of the committee, again, for the record, Senator Gary Romine, representing the 3rd Senatorial District, here to present to you Senate Bill 746. Senate Bill 746 is an arbitration bill. This is a mutual agreement between employer and employee on a method of resolving issues in their employment status. And it gives the opportunity to deal on a more casual basis the issues that can come up during employment opportunities. Over several years, the arbitration agreement has been accepted, but with court processes and with a lot of resistance, we need to codify and reestablish the value of arbitration and allow it to be a part of the system. Allow it to be part of the system of resolving employment issues. With that, Mr. Chairman, I'll be happy to answer any questions.
Any questions of the witness or question of the senator? Sorry. Any questions? Seeing none. Senator, do you have witnesses?
I do not have a list, but I hope there's folks here.
Anyone in support of Senate Bill 746?
Good afternoon. My name is Janet Mark. I'm an Associate General Counsel at Hallmark Cards in Kansas City, and I am here in support of Senate Bill 746. Arbitration is widely used in the employment arena to resolve claims that are brought either by the employer or the employee. And the reason arbitration is used is because it has many benefits over litigation. I put those in my written testimony. But basically, it's cost effective, it's quicker, and it's much more informal, so employees can, if they so choose, resolve their claims without an expensive lawyer involved. The United States Supreme Court has recognized these benefits in arbitration and has repeatedly endorsed the use of employment arbitration as a way of fairly, quickly, and easily resolving claims. Federal courts and other state courts have followed suit and enforced arbitration agreements, including just 6 weeks ago by the United States Supreme Court, when they again reiterated that arbitration agreements must be on the same footing as other contracts. Unfortunately, the situation is starkly different in Missouri. Missouri state courts are truly outliers. They're unique and quite notorious for their hostility towards these arbitration agreements, again, between an employer and an employee. Over the past 8 to 10 years, they've created an anti-business environment where they've eviscerated long-standing legal principles relating to contracts. And they've created a moving target where no arbitration agreement, or very few, are ever found to be valid. And in doing so, they've ignored the Supreme Court direction to treat these employment arbitration agreements on the same footing as other contracts. The Missouri courts have refused to enforce arbitration agreements for a who's who of Missouri employers, including Anheuser-Busch, Blue Cross Blue Shield, Kansas City Chiefs, Bristol Manor, McBride & Son, Cintas, and Hallmark. Senate Bill 746 seeks to rectify this by taking jurisdiction away from the courts when deciding initial issues of arbitrability. So basically, is this a valid contract to enforce? And instead, the bill will place that authority in the hands of an arbitrator who is mutually agreed upon by the parties. This arbitrator is usually a lawyer or a former judge. The bill provides guidance to the arbitrator when making these decisions on enforceability. For many years, arbitration has been used in the traditional labor setting, so between unions and management to resolve disputes. And this Senate Bill 746 does not impact that at all. Those arbitration provisions remain fully enforceable. Again, we are talking about a private contract between the employer and the employee. At Hallmark, we give copies of the arbitration agreement to any person who is considering employment at Hallmark. And if they want to choose to sign that arbitration agreement, they do so before their employment begins. So you may hear opposition to this bill and to arbitration in general, that every employee deserves his or her day in court. And I absolutely agree. In fact, arbitration is a court. Every remedy available in the court system is available in arbitration. Employees can raise any claim in arbitration that they can raise in a court of law. It's simply a different forum, and for the reasons I mentioned, a better forum for resolving those claims. In fact, employees are more likely to get a hearing on the merit in arbitration than in litigation because it's faster and cheaper. And again, as I mentioned, an employee can choose to not hire an expensive lawyer and resolve those claims on his or her own. Parties are less likely to file for and obtain summary judgment in arbitration. So again, a lot more hearings on the merit occur. And keep in mind, employers are held to the same rules. Any claims that an employer has against an employee must be arbitrated as well and cannot be litigated in court. You may also hear complaints about forced arbitration, which is kind of a new catch term. Anytime we are deciding whether to accept a job or not, we have decisions to make on the terms and conditions of that job offer. Is the salary sufficient? Am I okay paying a monthly parking fee? This company doesn't provide retirement benefits, but other companies provide a matching program with stock options. Am I going to be okay with that? Agreeing to arbitrate is just another of these terms to consider and decide whether it's for you or not. It's not forced. Employees should and definitely do make informed decisions after reviewing the program. And for the reasons listed above and in my written testimony, we believe it's a beneficial term of employment. Finally, you may hear that arbitration is unfair because arbitrators are paid by employers and therefore will find for the employer in order to get repeat business. It is correct that employers pay the majority of arbitration costs, and the reason for that is simple. Employees should not be prohibited by cost in bringing claims against an employer. And so the employer does front most of those, or pay for most of those costs, which again is another benefit of arbitration, because in litigation, the plaintiff must pay a filing fee of $400 and other expensive costs. In any event, we believe arbitrators do the right thing. They're not motivated by self-interest, and there's no evidence to the contrary. And there are safeguards in place. Parties mutually agree on the arbitrator, who is a lawyer or a former judge. American Arbitration Association arbitrators comply with a code of ethics that requires them, among other things, to not be swayed by outside pressure. And arbitrators are lawyers or judges who are bound by those codes of conduct as well. AAA arbitrators must disclose relationships that impact their judgment or that may sway them one way or another. And of course, if there's a concern about fraud or misconduct on the part of the arbitrator, there is an appeal to the court system. I strongly urge the passage of Senate Bill 746 to provide for fair arbitration agreements and to curtail the court's activism, anti-business sentiment, and hostility to employment arbitration. Thank you.
All right, thank you for your testimony. Did you say the Kansas City Chiefs did support this?
They do.
I'm good. Joking, I'm joking on that. Questions of the witness? Seeing none, thank you for your testimony. Anyone else in favor? Senate Bill.
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries in Missouri. I'm going to be very brief since the previous witness covered all my points. I'm happy to answer any questions.
Questions of the witness? Seeing none, thank you. Next in support.
Brian Bunn, Missouri Chamber of Commerce and Industry, like to go on record in support of the bill.
Thank you. Any questions of the witness? Seeing none, anyone else support?
Susan Henderson, we're on behalf of J.E. Dunn, just going to go on record in support.
All right, thank you. Any questions? Seeing none, that's in support.
Thank you, Mr. Chairman. Nancy Gibbons, representing the Greater Kansas City Chamber of Commerce, also in support of the bill.
All right, thank you for your testimony. Question? Next in support.
Mr. Chairman, Brad Jones with the NFIB, and we would like to register our support.
All right, questions? Seeing none, thank you for support.
Melissa Freeman on behalf of Senate Corporation, just like to register in support.
All right, questions of the witness? Seeing none, thank you for your testimony.
Mr. Chairman, members of the committee, Fred Riley today representing Parson and Donald to.
All right, questions of the witness? Seeing none, thank you for your testimony.
Mr. Chairman, Jason Clem, on behalf of Kansas City Power and Light, in support of the bill.
All right, thank you for your testimony.
Mr. Chairman, members of the committee, Calvin Call with Missouri Insurance Coalition would like to go on there in support of the legislation.
All right, thank you for your testimony. Questions of the witness? Seeing none, thank you. Anyone else? Seeing none, opposition? Anyone in opposition? For the committee's sake, before he starts his testimony, we are going to be going into executive session right after this bill. So, you're ready.
Good afternoon, Mr. Chairman. My name is Jonathan Burns. I'm an attorney in St. Louis. I represent employees and do employment discrimination law in St. Louis. I am testifying here today on behalf of both MATA and the National Employment Lawyers Association in opposition to this bill. With all due respect to the counsel from Hallmark, I think her description of arbitration, one, is utopian, and two, is completely inaccurate as it relates to this bill. What she described as arbitration is not consistent with the terms of this bill at all. As this bill is drafted, arbitration can be used in the employment setting as an end run around the employment discrimination laws in Missouri. It would effectively nullify and void those laws. Arbitration agreements, as has been said, are agreements that are typically presented to an individual at the outset of their employment. And they have to agree to that arbitration agreement or reject the job. So they have to make a choice of entering into an agreement that the employer has drafted unilaterally or not work. That's the proverbial gun to the head. At this point, the arbitration agreements that we see in the employment setting, these are fundamentally different than what we see in the union context. We do not have in these situations equal bargaining power at all. In the union setting, you have much more equal bargaining power, and those arbitration agreements are often much more fair in terms of the company and the employee. However, That is not the case when we talk about individual employees who are working at will, which is what this bill covers. The way the current system works is that if an individual signs off on an arbitration agreement and then a dispute later arises, he or she has the opportunity to go to court if they believe that the arbitration agreement is so fundamentally unfair that it needs to be invalidated. And the courts can serve in that role of protecting against unfair agreements. What this bill seeks to do is eliminate that protection. It does it by doing two things. One is, whereas right now, courts can decide whether or not an agreement is unfair or not, that decision is now being sent to an arbitrator. And then the second part is the real kicker, which is that the employer has the power to unilaterally select who that arbitrator is. And there are no restrictions in this bill whatsoever regarding who that arbitrator could be. It could be the HR manager of the company. It could be the CEO of the company. So that individual who has a vested interest, obviously, in the dispute is the one who is making the decision about whether or not it's a fair agreement or whether or not the employee can prove out their claim or not. Obviously, that is not, I think everybody would agree, that is not a situation that is fair to both sides of the equation. This, what I'm suggesting, that the employer can select exactly who they want to be the arbitrator, is not some sort of abstract or hypothetical argument I'm making here, a worst case scenario. There's a very recent case that came out of Missouri, and Chairman, you mentioned the Chiefs. This one had to do with the Rams, the former St. Louis Rams. In that case, Hewitt versus the St. Louis Rams, an individual brought an age discrimination claim against the Rams after he was fired. The individual tried to bring the case in court. He had an arbitration agreement. The NFL drafted the agreement. And who was identified as the arbitrator for this dispute of age discrimination against the Rams? Roger Goodell, the commissioner, CEO of the NFL. In our case, that case went up to the Supreme Court, and the Supreme Court said that is just so fundamentally unfair, we cannot enforce the agreement where Roger Goodell gets to rule upon an age discrimination claim. So fairness won out there. But this bill would allow Roger Goodell or the HR managers, the CEOs to serve as the arbitrators. And that would effectively invalidate all of the employment laws, because those obviously people who have an interest in a claim like that are never going to rule fairly and impartially. So that's my big problem with this bill. But also it requires a finding that these agreements, arbitration agreements, are invalid no matter what unfair conditions are placed in that arbitration agreement. Maybe the arbitration agreement imposes a $10,000 payment, requires a $10,000 payment by the employee as a condition going forward. Under this bill, the way it's drafted now, that can't be invalidated. The arbitration agreement has to still be enforced. This bill says that if an employee refuses to sign the agreement, and says, I refuse to agree to this arbitration agreement, and the employer says, fine, we still want you to continue working, and that employee, under those circumstances, agrees to go forward working, the arbitration agreement, even though the employee has explicitly rejected it, can still be enforced against that employee per the terms of this bill. So these are just some of the reasons why we oppose this bill and why we think that the language in the bill as drafted has some fundamental flaws. Thank you for listening.
Questions of the witness? Senator?
I'm kind of confused. I don't know much about arbitration, other than I'm somewhat familiar with union arbitration. She said this is nothing like. Is that what you said earlier?
There are some very fundamental differences, yes, Senator, between what is being covered in a bill like this and arbitration in the union context. In the union context, the sides have more equal bargaining power about who gets selected for the mediator, to be the arbitrator. They have more equal bargaining power about the terms under which that arbitration claim is litigated.
So this is a practice that already exists, they're just trying to extend it to equitable employees. Is that what I think this is? Is that correct in that assumption?
They're trying to take, there's certainly arbitration in the union context. And they are wanting to expand it to the at-will employees, so outside the union context. The same concept of arbitration, but they are doing it in a manner that is far more unilateral, far more, the scales are tipped far more towards the employer than they are in the union context.
Right, so what do you suggest as far as arbitration for the process to be more fair? So an outside agency, I'm just trying to kind of get it. I mean, what is it that you suggest so that the process, if there was arbitration, would be more fair?
There is no objection to arbitration per se when it is truly entered into by mutually consenting parties, assuming that the terms of that arbitration are fair. So if a individual agrees to arbitration under certain conditions, that can be perfectly fine. The problem is where the safeguards that are currently in place. Today, if there is some sort of purported arbitration agreement and the parties dispute about whether or not it's enforceable or valid or fair, they can go to the courts and have the courts decide. Somebody who's not overly influenced by one side or the other. To me, that's the system that's in place now. It is a good system. The problem I have with this is that it's altering it by taking that decision-making role of the courts and putting it in the hands of an arbitrator who can be unilaterally selected by the employer. That completely now, where we have a level playing field currently, that completely tilts the scale one way.
Further questions, Owens? Seeing none, thank you for your testimony.
Thank you.
Anyone else opposition?
Hello, Rachel Greenhouse again with Empower Missouri, and I'm just going to go on record in opposition to 746 in the bill. We, like the previous testimony just said, we believe that arbitration should not be forced. It creates an unequal bargaining power between individual employees and their employers. So we would like that that the constitutional right to a jury be preserved. And with that, I'll take your questions.
Questions? Seeing none, thank you for your testimony. Anyone else opposition? Opposition to Senate Bill 746. Seeing none, informational purposes. Seeing none. Senate, any vote?
Thank you, Mr. President, Mr. Chairman. We are an at-will state, and this is a useful tool for certain businesses that they want to operate. We should have the opportunity for free market, free enterprise for individual businesses to set up an arbitration agreement. If employees do not want to work for that type of environment or company, they have other options. So with that, Mr. Chairman, I'm going to ask that this committee consider and pass this bill. Thank you.
Thanks, Senator. That closes the hearing on Senate Bill 746. Thank you, Senator, for good to us. All right, I would now make a motion to go into executive session. All those in favor say aye. Aye. Those opposed? All right. First thing we're going to hear is Senator Cunningham's bill. There is a committee substitute for that. It has to do with the workers' compensation grant. This was from rural fire departments. We've heard of that. Basically, what the substitute does, the only thing the substitute does, it runs the money. If there is grant money or funding source, it runs it through the fire marshal's office. They would distribute the funds. Difference in the substitute. So this is one of the rural fire departments that are trying to help on workers' comp. They fund some of the smaller fire departments that have no resources.
Make a motion to adopt sub.
Motion, second by Senator Lott. All in favor, say aye. Aye. Opposed, ayes have it. I would now entertain a motion to consider to pass Senate Bill 613 first, as amended by the substitute. Motion, second.
Make a motion to pass.
Second.
Second.
See, roll call here, Patrick.
Senators Parson,
Aye.
Lively,
Aye.
Munzinger, Wallingford, Watson,
Aye.
Wheelan,
Aye.
Curls,
Aye.
Walsh.
By your vote of 8-0, you do pass Senate Committee Substitute for Senate Bill 613. Next up, we have Senate Bill 700, this is Senator Schott's bill. It refers to the split at point, and it really has to do with compensation, workers' compensation insurance. Remember that there was a limit of $1,000 on that before it paid. It's actually, I believe it expands that to like 20%. The other thing that was in this, you might remember, there was only 1/4 of the year you could use. Before that, this would allow you to use any one of the 4 quarters, is what that is. So, with that, I would make a few motion to pass Senate Bill 700. Second by Senator Lively. I'm sorry, discussion. Saying none, got to call roll.
Senators Parson, Lively, Munzinger, Wallingford, Watson, Wheelan, Curls, Walsh.
Aye.
By your vote 8-0, you voted to pass Senate Bill 700. Next up, Senate Bill 702. I want to start the committee. Senator Munzinger. Recapture overpaid unemployment benefits. You want to cover that real quick?
It allows the department to recapture unemployment benefits that were overpaid. For one reason or another, but it allows the department to retrace their payments. And I move to pass.
Motion to pass, seconded by? Second by Senator Lively. Discussion. Seeing none, got to call roll.
Senators Parson, Lively, Munzinger, Wallingford, Watson, Wheelan, Curls, Walsh.
By your vote 8-0, you voted to pass Senate Bill 702. I now entertain a motion to go to count. So moved. So moved. All those in favor say aye. Aye. All right, we're back in session. We are now ready for Senator Brown. You patiently wait for Senator Brown? You got to see our committee in action. Look good. Notice after the other 2 bills, not a whole lot of people left, just so you're aware of that.
I know. Thank you, Mr. Chairman, members of the committee. Senator Brown, representing District 16, here for your consideration today. Senate Bill 598 and there's actually a Senate Committee substitute has been passed out, and that's what I'll be speaking to. What this act does is permits public bodies to opt out of prevailing wage requirements for projects which are $750,000 or less. And, the substitute would remove the requirement of paying prevailing wage on all projects that cost $750,000 or less. In 1931, James J. Davis, a senator from Pennsylvania, and a former Secretary of Labor under 3 presidents, and Representative Robert L. Bacon of Long Island, sponsored the Davis-Bacon Act. The Davis-Bacon Act was passed by Congress and signed into law by President Hoover on March 3rd, 1931, and the first prevailing wage law was passed. Leading up to the passage of the Davis-Bacon Act in 1927, the contractor employed African-American workers from Alabama to build a Veterans Bureau hospital in the district of Congressman Bacon. Prompted by concerns about displacement of local workers by migrant workers and competitive pressure toward lower wages, Bacon introduced the first version of this bill in 1927. Over the next few years, Bacon attempted to introduce variations on prevailing wage bill 13 times. And finally, in the midst of the Great Depression, with local workers complaining about cheap labor taking their jobs, and congressmen frustrated that their efforts were to bring portfolio projects home to their districts did not result in jobs for their constituents, the Hoover administration had to request that Congress reconsider the act one more time as a means of preventing falling wages. The bill was signed into law by President Hoover March 3rd, 1931. In 1957, Missouri enacted prevailing wage. Since that time, Missouri has artificially inflated labor rates for projects that are being paid for by tax dollars. We have seen costs associated with building public works, programs shrink the size of projects, delay projects, and oftentimes projects being canceled due to cost. And this it seems like it's not such a pressing area, maybe in the urban areas, but in the rural areas, when I have a meeting with any of my constituents, this is the #1 issue that they bring up. You know, since the Supreme Court of Missouri said that all repairs or all painting or whatever is prevailing wage, it's really hurt outstate Missouri. And so that's what brought this legislation forward. So our schools are having trouble, the small schools. There's a letter that was passed around from rural school districts, charitable organizations that receive state funds don't complete their projects, or they scale back the projects. And so we're trying to listen to the constituency and allow them to move forward with some of the smaller projects or even repairs, roof repairs, things like that. You know, that's the gist of the legislation. Anybody have any questions of the bill presenter? See, none, have anybody call up or just call them in order. All right. Anybody in support? Senate Bill 598, grab a seat. Matter of fact, anyone else in support, just come on and grab an empty seat. That way we'll just kind of keep things moving. Just come on up. Ma'am, you're up, introduce yourself and make a statement.
Rachel Payton, Deputy State Director with Americans for Deputy State Director with Americans for Prosperity's Missouri chapter, and we want to go on record in support of this bill because it's going to save taxpayers money.
Okay, we want to remind everybody, make sure you fill out your witness form. Those of you who are not used to being up here, so make sure you fill it out, leave it on the desk. We'll round it up in a little bit. Any questions this week? See now, thank you very much. Next.
Hey, Mr. Chairman, Brian Bunn, representing the Missouri Chamber of Commerce and Industry. Without seeing the committee substitute, it sounds like House Bill 1700 Representative Bill Land. We supported that earlier this year to the extent that we feel like it could free up some projects that aren't being commenced right now. We feel like that's good for economic development in our rural counties, and that's why we support it.
Okay. Any questions this witness? Seeing none, thank you very much. Anyone else in support? Senate Bill 598. Support Senate Bill 598. I have a request for the next witness. Yeah, one minute. I have a request for the in opposition. Next up will be Leon Keller. Mr. Chairman, I have a bill on another committee I have with you. Okay. Thank you very much. Thanks for your patience also.
Thank you.
That bench gets hard over there. I've sat there before. Thank you very much.
I'm Leon.
You may proceed.
I'm sorry.
You may proceed, Mr. Keller.
I'm Leon Keller. I'm president of Meyer Electric Company, and we're in opposition of both bills. And
are you only talking on one bill?
Okay, 598. Yeah. We're in opposition of that due to we work all over the state of Missouri, and not St. Louis, Kansas City, but we rural areas. We work about 180 people. And we work in probably for almost every prevailing wage in the state of Missouri. And they're all different prevailing wages.
Go ahead, you said this might work.
And the situation you have with prevailing wage is it sets a floor, so to speak, to be a fair wage for people, for the construction industry. I'm 73 years old. I've been doing this for 55 years. I've seen all sides of this business. And they talk about low scale work and so forth. The face of our country is changing. We now have migrant workers, immigrants, and I'm on projects where there may be, in fact, there was a project 2 years ago in Columbia, Missouri, 60 people from out of state, bricklayers, 15 hod carriers. I was over there at 7 o'clock on a Sunday night, and they were working. When they leave the project, they get in their campers and they go. Our 180 people are all community people. They're in these school districts that we talk about. Some of their wives are teachers. They're PTA members. They're vested in these communities. We pay them a fair wage, but in turn, they are a taxpayer for that community. So the money is going back to the community. Whenever they get their paycheck, probably 90% of that is spent within the state of Missouri for sure, and most of it's spent within that community. So this money rolls over and over. I watch the people that come in from other areas, and on Friday, if you go there on Friday, you will follow them to wherever they buy money orders to send the money out of state. The only money that comes back to the community will be for subsistence while they're there, fast food places, whatever of that nature, and possibly where they get their campers parked to the campground. There's a total difference in what's going on in our state of Missouri compared to what it was maybe 25 years ago. And our people are dedicated to the communities they live in. And I think this is a big factor in looking at this and saying, you know, cheap is always not cheap to begin with. And the money not going back to the community, not staying in the state is a big factor. And actually, you lose your tax base. And you can't, let's say I've got 6 people living in Marshfield, Missouri. I've got people living in Rolla, St. James, Marshfield, all over the state of Missouri that have gone through, they've gone 5 years of program. They've committed 5 years to apprenticeship program, over 1,000 hours of classroom time on their own time to become qualified people. When we get rid of this, it really just devastates all these people. Not just my 180 employees, many, many other employees, whether they're union or non-union. Because a lot of people think that if you take away the prevailing wage, it's going to let Jim Jones or, you know, a local guy, he's a good guy, to have an opportunity to do this job. And that's not necessarily going to be the case. In fact, he probably will not. I get flyers about once a week telling me that they can have 25 people for me within 48 hours shipped in here, workers. And if I give them 2 weeks, they can get me up to 500. Now, that's not right. And that's basically what I'm about to say. So, anybody have any questions?
Just a moment. Senator Walker.
I just have one. Did you ever work with the tools as an electrician?
Yes, I did.
Can you fix that mic?
I would have to try. I don't think it's me. Maybe.
I think I agree with the senator on that one for sure. Surely to goodness, you know, we've been having this problem with microphones for I can't tell you how long. You know, and it just interrupts the whole flow of conversation. We have got to get these things fixed. And
in due respect, I have technology people who could probably do it.
Well, maybe you need to come over and give us some examples. But any further questions this witness? Thanks so much, Mr. Keller.
Thank you.
Today. Next up is Dennis Palmer in opposition. Dennis, would you mind coming up, sir? be sure to introduce yourself, who you're with, and Mr. Keller, be sure to write your witness form, please, sir. Okay, okay. Thank you.
Good afternoon.
Good afternoon.
My name is Dennis Palmer. I reside in Columbia, Missouri. I'm a small electrical contractor. Our company's been in business for over 20 years, providing commercial, industrial, electrical work throughout mid-Missouri. I represent 15 electrical contractors in the mid-Missouri area that are signatory to the IBEW. These contractors employ over 450 of the highest skilled electricians in the region. And together we have invested a great deal into the electrical apprenticeship training programs. This training does not happen overnight. It requires 5 years of classroom instruction and our commitment to supervision during this time in order to make it possible for us to add highly qualified licensed electricians within our industry. The majority of my company work falls under the prevailing wage laws, and any repeal to any of the current prevailing wage statutes would be devastating. My company performs a great deal of work under maintenance contracts with public schools, local cities, counties, in which all of this work falls under this repeal. The contractual work makes up a considerable amount of our annual income. This proposed repeal will encourage inexperienced construction firms to enter the sector. It will bring lower construction wages and benefits, lack of quality apprenticeship training, leading to a less skilled workforce and prone to injuries and endangering Missouri's safety record. Prevailing wage regulations provide a level playing field for law-abiding contractors who have made an investment in their companies and in their communities. Low wages will equate to lesser quality of work and productivity, the elimination of quality employee health, insurance, and pension programs, along with potential failure to pay payroll taxes that fund the unemployment system and the workers' compensation system. All of us have heard the old saying, cheaper is not always better, and you get what you pay for. Well, now's the time to really reflect on what this could mean to all of us. Many governmental projects exist where there's no city, county, building, construction departments like these smaller rural areas that we've heard about. Thus, there are no inspectors to ensure that these tax-funded projects are meeting or exceeding building and national electrical codes. There's nobody there to check to see if a licensed electrician or supervised apprentices are actually performing a work of value. These locations include schools, city county buildings, and even the university campus. As a contractor and business owner, I find that higher wages promote increased productivity and decreases labor turnover cost. It attracts a higher quality labor force, reduces absenteeism, and increases overall morale. So I conclude that the current prevailing wage statute has a positive and solid impact on Missouri construction workers and their families. Higher incomes associated with prevailing wage legislation will generate more spending and more tax revenue for state and local governments than not. And as a company owner, it would allow us to maintain our highly skilled workforce.
Okay,
any questions?
Okay, thank you, sir. Any questions of this witness? Seeing none, thank you very much for coming in today. Anyone else in opposition to Senate Bill 598? Anyone else in opposition, raise your hand other than the gentleman sitting still. Will you come on up and grab a seat somewhere, please? Any open seat, feel free to jump in. And then we'll start with you, sir, since you were up first.
Thank you.
Introduce yourself, everybody, make sure you got the witness forms. Please leave on the desk there, and we'll gather them up.
Good afternoon, everyone. I'm Tim Weiss. I'm President and CEO of TJ Weiss Contracting. We're a commercial wall and ceiling contractor with offices in Lake St. Louis and Jefferson City. I'm here on behalf of the 300 hardworking middle-class union families who call TJ Weiss Contracting home. Whether they live in the Metro St. Louis area, Jefferson City area, Columbia, Rolla, Kirksville, Waynesville, these folks are actively contributing to make their communities strong and vibrant. I myself am a conservative. As I've said to you guys in the past, I tease them slightly to the right of Attila the Hun, but I believe there should be an emphasis on less governmental interference in our daily lives, and I'm a strong proponent of capitalism. Capitalism combined with American work ethic has made the United States the greatest country on earth. I'm also a realist. People can get greedy, people can get lazy, people can seek out opportunities to enrich themselves at the expense of others. Freedom is one of our greatest assets, yet absolute freedom without some laws and regulations is anarchy. Capitalism is also great, but absolute capitalism without some laws and regulations is chaos. Laws and regulations protect society as a whole, and they keep the playing field level and help keep the honest man honest. The Davis-Bacon Act established the prevailing wage was an effort by two Republican congressmen, James Davis and Robert Bacon. It was put into place to protect local contractors and their local workforce from the out-of-state migrant contractors and their migrant labor, as you've heard by Senator Brown brought this before us. Once the contract was completed, the migrant workers left, and there was nothing left in the community. The Davis-Bacon Prevailing Wage Act leveled the playing field for all contractors bidding on these projects. The area wage standard was determined and provided in the bid documents for use in bid preparation by both local and migrant contractors. All contractors had the same opportunity to compete due to the stability in the wages. The law did protect a segment of our society, the local contractors and their local workforces. Now, I know some of you come from rural agricultural communities, or you're personally connected to the agricultural industry yourself. The agricultural industry also needed a level playing field. So the government stepped in with subsidies and programs for the agricultural community. These programs also fly in the face of true capitalism, but they were put in place to level the playing field and to protect, once again, a certain segment of our society, local agribusiness. A pure capitalist would say that the market should set the area wages, not some governmental bureaucrat. Well, with the current Prevailing Wage Act, the market does in fact set the wages. Contractors in each county have the ability to report their hours paid for all their workers. My company reports all of our hours, man hours worked, and labor rates paid in each county during the year. All other contractors can also report their hours and wages as well. If union companies do not work in a county and all the construction work performed in that county was performed and reported by open shop contractors, then the prevailing wage in that county would be the open shop wage rate. Why are we changing or eliminating something that is designed to protect the local area's workforce and has worked in the past? If open shop contractors in the communities in which they operate care so much about that they're trying to change the law, why don't they care enough about reporting their man hours and wages? Why are we doing all this? Because they choose not to use the system that's in place. It's pretty easy. Be responsible, do what you're supposed to, and things will work out. Now, I'm sure you guys are all being pushed and pulled in many directions by many different people and organizations. I applaud your efforts and desires to minimize governmental interference in our lives. But I think in this case, you're being misled, and your intent to protect Missouri taxpayers will backfire. Maybe a few buildings might be built a little bit cheaper, but in larger metropolitan areas, the local construction industry, both contractors and the workforce, will suffer. When the local construction industry loses, the local community as a whole will also suffer. Our middle class is shrinking. I do see a growing chasm in regards to income inequity. The causes are numerous, be they evolutionary, such as the economy shifting from manufacturing-driven to a service-driven economy, to educationally with some poor performing schools, to socially with the lack of parental emphasis on good education, just to name a few. It's taking well over 100,000 solidly middle-class families in the construction industry and turning their career choice into low-income jobs going to turn our economy around? Or will it further exacerbate the divide between the haves and the have-nots? I ask you to protect local construction contractors, their local workforces, and their local communities. Please leave the prevailing wage laws alone. Missouri contractors, Missouri tradespeople, and the Missouri communities they live in will thank you. Does anyone want to have any questions?
Okay, thank you very much. Any questions of this witness? Seeing none, next up.
My name is Dennis Corrigan. I'm the chairman and CEO of Corrigan Company Mechanical Contractors in St. Louis. My brothers and I operate a 120-year-old mechanical contracting company. We do all facets of plumbing, heating, air conditioning, industrial piping in eastern Missouri. First thing I want to say is a little bit of this will be repetition, but I find it's significant but ironic that Senators Davis and Bacon were Republicans, and that back in the day, the workers of New York, as a public works project, were going to build a VA hospital, and they were going to sub it out to people from Alabama and Texas, and the local workers said, no, you're going to pay us a wage in which we can pay our rent, feed our families, and send our kids to school. A very noble effort. And here we are, 80 years later, pretty much talking about the same thing. So I have some prepared statements I'm going to read. A little bit of repetition, but not too much. The prevailing wages exist in Missouri State County.
We don't allow reading testimony, sum it up or something. Submitted in writing, you got written testimony. How much have you got there?
Not much, a couple of minutes.
Okay.
Well, the prevailing wages exist in Missouri State, County, and city construction projects for over 40 years. The current law recently amended in 1975. The law ensures the state pays a fair wage for construction projects by paying, through successful contract bidding, the wage and benefit packages being paid by the majority of the contractors on private sector projects. The law further balances the requirement that the state select the lowest bidder by ensuring that it isn't enhancing a race to the bottom. While it's important to see how laws and regulations can be improved to reflect the realities of today's economy, it is equally important to recognize the need for the prevailing wage and the important role it plays in safeguarding good wages for quality work. Attaches a document I presented 3 years ago with a couple of additional points. First, simply what is the prevailing wage and how is it set? Simply, the wage is the total cash wage and fringe benefit being paid in a location by the majority of those performing work at issue, such as electricians, plumbers, pipers, operating engineers, laborers, carpenters, etc. Contractors submit their wage and benefits and hours worked in the classification, and the Department of Labor determines the prevailing wage and benefit package in this county. By this process, the state ensures it is paying the same as the majority of the private sector and does not tip the scale downward through the power of the state treasury. This process is counterbalanced by the fact that the state must also select the lowest bidder. The system ensures the state, this is important, that the state remains a leader in good wages for workers of the state and simultaneously avoids government abuse through the bidding process. What's this discussion not about? The discussion is not about whether Missouri should be a right-to-work state, whether unions are good or bad. All contractors and and working men and women, union or non-union, benefit from the prevailing wage, as does the state. Competitive wages and benefits create a skilled workforce willing to stay in the construction trades or enter the construction trades. Good paying jobs decrease the amount of working citizens still dependent on public assistance. Higher earners can purchase more goods and services, increasing sales tax revenue, and higher earners pay more income taxes. How can the prevailing wage and regulations be updated and improved? The law does create an administrative burden on the state to review certified payrolls and on contractors to ensure they are submitting proper paperwork. Ambiguity also exists regarding construction work versus maintenance work. A simple solution would be to follow the lead of other states and establish some dollar thresholds for projects before prevailing wage applies, rather than join the majority of states who have no.
Kind of got to wrap it up.
Okay.
I've got another bill I got to.
20 seconds. No prevailing wage. 750,000 is too high. Submitted here is a table from the U.S. Department of Labor. In summary, we consider updating a 41-year-old Missouri law. Yes. Any decisions made to alter current law should be made with the facts. The notion that reporting hours is an unusual burden, I find hard to believe. In the age of computers, cyberspace, reporting hours is an accounting procedure as simple as 2 clicks to a keyboard.
Anybody on the committee got questions? And I apologize to cut you off, but I asked for
I had one more
everybody.
sentence.
And maybe they can ask questions. I know you've probably come a long way to get here, but I do that out of respect that the committee has to move on. And a written testimony, we would much rather you hand that in and then summarize
I'll do that.
what it is. So I
I'll do that.
want to be respectful, but I want you to say why I'm doing it. Questions?
Mr. Gordon, how many people do you employ?
About 400.
Okay. You just talked about how that oftentimes people refer to the reporting process as cumbersome. Do you report your hours electronically?
Yes.
State?
Yes.
Thank you. And have you found that burdensome?
No, not particularly.
Okay, thank you.
That's what the rules are.
Any other questions? I'm sorry, sir. You can-
I'm finished, thank you.
Okay. Any other questions of the witness? Seeing none, thank you for your testimony. Opposition?
Thank you, Chairman Parson, for allowing me to testify today, members of the committee. My name is Dan Weinstraw. I'm the Executive Director of Painting and Decorating Foundation in St. Louis, as well as the wall and ceiling contractors in St. Louis. Also a taxpayer in the city of St. Louis County, Franklin County, St. Charles County, Greene County, and a number of other counties. And so I understand taxes and I understand prevailing wage. And I think I understand it probably better than most because I had the opportunity to serve on a committee that Senator Greene put together a number of years ago, where we sat here all summer and discussed prevailing wage. And quite honestly, a lot of the school superintendents, no, not to be mean, they didn't even understand what they were talking about, and they learned what prevailing wage really was. They didn't understand that it was people reporting the hours worked in their area. They just thought it was a burdensome thing that came out of St. Louis, and it wasn't. You know, I have to ask this question. My offices are in an area of St. Louis County where there's a lot of landscaping companies. And let me tell you, did you know that landscaping companies have homes for all those employees to live in our neighborhood, an industrial neighborhood? It happens because that is cheap labor. What happens when you get rid of prevailing wage laws is that you have a bunch of contractors who come in who are what we call 1099s. Everyone's an independent contractor. They don't work for a company like TJ Weiss. They work independently. They're out there. They have no insurance. They don't pay taxes. You know, I have to ask you this question. Why is it that if I go into a community, all the gas prices are the same in that community? Is that prevailing wage?
I'm sorry, to switch minds there.
Okay. You know, isn't it amazing that if I go up and down a street, everyone's the same price on their gas? Do you think every gas company has the same cost of doing business? I don't think so. I don't think it's possible. Why is it when I go pick up my prescription at the drugstore, that everyone has the same copay and everyone's paying the same. What is that? That's the market saying that this is what it costs. And when we say that we want to create a prevailing wage law that limits it to $700,000, let me tell you something. All I have to do is break it up into $700,000 segments for the entire project. It may be a $5 million project, but each job will be bid as a $700,000. I also can tell you this, that for $700,000, you can get a lot of painting work done. A heck of a lot, more than would ever be done on a job. And when a school district says, well, we can't do our maintenance painting, yes, you can. Maintenance painters can paint in the school district. They don't have to be paid prevailing wage. They work for the school district. So, I mean, we're making up a lot of, I think there's some fabrication of what really goes on. And with that being said, again, I want to thank you for allowing me to, but I want to finish with one thing, and this really upset one of my contractors the other day. And it reminds me when I crossed this bridge coming into Jeff City, that is out for bid on prevailing wage. It was done a number of years ago by a company out of Tarpon Springs, Florida. At that time, they swept the lead paint into the river because it was a total lead abatement job. It was done prevailing wage. You know what? That's out for bid again. Guess what? They need to abate the lead again. Why is that? It was a lead abatement job when it was done by this company out of Tarpon Springs, Florida. How do they beat prevailing wage? Well, they misclassify the worker. They make only a number of the workers really workers and everyone else is a supervisor. Then they go back down to Tarpon Springs and carve up the dollars and cents that they made on the job on the state of Missouri and made a taxpayer. Thank you.
Questions of the witness? Seeing none, thank you for your testimony. Anyone else opposition?
Mr. Chairman, members of the committee, Rodney Gray, appearing here on behalf of the Heavy Constructors Association of Greater Kansas City, a voluntary group of heavy and highway contractors who have existed for over 75 years in the Greater Kansas City metropolitan area. And they simply think that laws like this that are in the attempt to be, I've seen Senate committee substitute, but in looking at the original Senate version, simply makes groups like theirs, employers like theirs, less competitive when they move outside the metropolitan area. And certainly they would like the opportunity to work in all areas of the state. So they, in that regard, they're in opposition to this bill. Be happy to answer any questions.
All right, thank you. Questions of the witness? Seeing none, thank you for testimony. Next.
Good afternoon. I'm Denise Hasty. I'm Vice President of Advocacy and Registered Lobbyist for Associated General Contractors of Missouri. And you've heard many of the points that I was going to make already today, but the AGC is opposed to a repeal of the prevailing wage laws. And I would remind the body that in 2013, a significant effort went forward to do a reform to how the calculation methods on prevailing wage. And those have not had much time, the collection of that data hasn't had enough time, we haven't had enough time to see if that's worthwhile, if that's achieved the goal that was the goal at the time. And I just think the members of our association believe that throwing the baby out with the bathwater is not appropriate at this time, for all the reasons you've heard from other contractors outlined this morning.
All right. Questions of the witness? Second.
Good afternoon, Ms. Hastings. How many members do you have?
We have 500 member firms in 110 counties in the state of Missouri.
Okay, are they both union and non-union?
Yes, they are. Yes, they are. And neither business model wants prevailing wage repealed.
And hard to get 500 individual contractors to all agree on one issue. Thank you. Thank you for your testimony.
Any other questions? Seeing none, thank you for testimony. Anyone else opposition?
Senators, my name is David Clarich, today appearing in opposition to the legislation on behalf of the Mechanical Contractors Association, Eastern District in Kansas City. I have written testimony, several things to add. I'd ask that you submit this both to your record and to your attention.
We will do so. Any questions of the witness? Seeing none, thank you. Anyone else opposition?
Rachel Greenhouse, Empower Missouri, we're just opposing it.
Any questions? Seeing none.
Thank you, Mr. Chairman. Nancy Gibbs, representing Construction Employers Coalition, also opposed to the bill.
Questions of the witness? Seeing none, thank you for testimony. In the interest of
Hi, Mr. Chairman, Terry Briggs, Registered Lobbyist Site Improvement Association. We're in opposition to the bill. I'd like to answer any questions.
Questions of the witness? Seeing none, thank you for your testimony.
Thank you, Senator.
Next.
Mr. Chairman, members of the committee, I was based on behalf of Missouri and go on record in opposition. Point out to the committee, the very first state to pass a prevailing wage law was Kansas. They're also one of the early ones to repeal on a statewide basis, which is what the original 598 would do. That was 1985 and 1997. Nonpartisan legislative study committees of the Senate Labor and Industry Committee researched that and found that the promises that had been made about reduction of per square foot school construction costs had not materialized. There were real reductions in wage rates, but they were compensated for by increases in costs associated with job site injuries and other construction delays. They negated that benefit, gave no benefit at all, but was really hurting families and their capacity to support their families and success both in school and elsewhere.
Questions of the witness? Seeing none, thank you for your testimony. Next.
Mark Dalton, the St. Louis, Kansas City Carpenters Regional Council. I'm opposing the bill. I think everything was pretty much summed up earlier by a lot of the contractors, business owners.
Questions? Seeing none, thank you. I'm sorry.
How are you, Mr. Dalton?
Good, how are you doing?
I'm good. How many contractors are affiliated with your organization?
Yeah, we have about 1,200 contractors affiliated.
Thank you.
About 22,000 members.
Thank you.
Senator Lott, what type of work do you do?
As far as the carpenters that we cover, we do foundation work, framing, insulation, roofing, siding, and more.
Further questions? Seeing none, thank you for your testimony. Next, opposition.
Adam McBride, Senator and member of the committee with the Missouri Laborers Unit, here to support our contracting partners in the industry. In opposition.
Questions of the witness?
Thank you.
Seeing none. Thank you for your testimony. Anyone else, opposition? Anyone, informational purposes only? Seeing none, that concludes the hearing on Senate Bill 598. Next up, Senator Saber, 606. There's a bill up there, look, 666. Here's a 606. That's right, you touch that, but it's in the call.
Thank you, Mr. Chairman, members of the committee. For the record, Senator David Saber, 29th District in Southwest Missouri, and I bring to you Senate Bill 606, which also has to do a little bit about prevailing wages. I'm representing our small communities in Missouri that are struggling to fix their public buildings and facilities. Their revenues are always just real close to the bone. You know, I'm representing small communities and counties and towns who are forced to ignore the needs of their community because prevailing wage laws compel them to pay for work far beyond the going rate. Number one, this bill revises the definition of construction as it relates to prevailing wages on public works projects by removing improvements, alterations, and major repairs. Under current law, construction includes, of course, construction, but also reconstruction, improvement, enlargement, alterations, painting, and decorating, major repair. My bill also specifies that construction does not include maintenance work. Maintenance work in my bill is defined as repairs that restore existing facilities to a previous state or condition or improve the utility or enhance the appearance of an existing facility, provided that the size, type, and extent of the existing facility is not changed. Maintenance work cannot exceed the cost of the original construction project. This bill would exempt charter counties from these changes. My goal here is to help small communities make the improvements they need to their public works, not go after our more urban areas, where perhaps maybe prevailing wages make more sense for them, and where there are more contractors and more competition to drive down the cost. Number two, one of the problems in my area, in the rural areas of the state,
is that there are often too few contractors that even participate in prevailing wage. So cities and counties are forced to hire contractors far outside the area, meaning the cost is higher and they are diverting tax dollars that should be staying in the community. You know, many small town contractors, they aren't set up to deal with prevailing wage issues, and it's an administrative headache. They don't have the, you know, some of them are just using QuickBooks. I have talked to many mayors and commissioners in my area and city administrators, and if the job is a small project, they have a hard time even getting someone to take the work that works with prevailing wage. And so they will wait for months and months and months before they will finally find somebody to take the job. One of the most significant needs is improvements or major repairs to our schools. Because of our current law, we're spending more money on these projects instead of putting money to work in the classroom. You know, we can have a discussion about whether or not the argument that skilled labor makes a difference when it comes to safety and quality of work. But it's a little bit more difficult to make that argument when it comes to maintenance and repairs. Building a 20-story high-rise building is altogether different than repaving a parking lot. When the town of Hollister, which is just south of Branson, they paved a little street intersection, concrete, and they had a prevailing wage bid of $17,366. They also took a bid from an independent contractor just to see what it would cost, and it only cost $1,800, a local private company. I think the system is broken as a result. And you know when it costs to replace the roof of an ambulance or a fire department barn is over $63,000 under prevailing wage, but only $22,000 on private property. I believe the system is broken. It needs to be fixed. We should remember that these are taxpayer-funded wages. The people that I represent in the rural areas believe that their tax dollars would be better spent maximizing the number of projects and getting the best bang for their buck, not paying top dollar for a project that could be done much cheaper if this law was fair. I'll be glad to answer any questions.
All right, thank you, Senator. Any questions, Senator? Seeing none, Senator, you have witnesses in support. Can you just call them up? Yep. Anyone's in favor? Senate Bill 606.
Thank you, Mr. Chairman, members of the committee, Brian Buck, representing Missouri Chamber of Commerce and Industry. Our Labor Council has identified this as an issue that they'd like to see fixed, taking maintenance out of that prevailing wage law. And they want to take a more measured approach to prevailing wage law reform. And that's why you just heard my testimony on the Senate committee sub of that last bill. So this fits in nicely with what we're trying to do with our Labor Policy Council. I'll be happy to take any questions.
All right, thank you for your testimony. Questions of the witness? Seeing none, thank you for your testimony. Anyone else in favor?
Rachel Caitlin with Americans for Prosperity Missouri chapter and like member says this is broken.
All right, thank you for your testimony. Questions? Seeing none. Anyone else in favor?
Mr. Chairman, my name is Joel Lawson. I represent the Missouri Association of Municipal Utilities. We'd like to go on record in support of Senator Sater's bill. Recently got off call this morning with City of Sightseeing on this issue. They have a power plant there, and one of the issues from when the Monroe City court case changed this maintenance issue is that in a power plant, when a boiler tube goes out, you've got to get that plant back up and running quickly to provide electricity to your citizens. You bring in someone to maybe weld the tube or something, or put a new bracket in or something like that. They're now having to pay prevailing wage today where they didn't have to do that previous to that case. And we're not building new power plants. We're just maintaining the power plant that we have. And we have many other cities across the state where if it's painting a water tower, that's not building a water tower. It's just the maintenance to prolong the life of the city's investment.
and we'd like to go on record in support. All right. Any questions of the witness?
Typically, I'm sorry, but typically, the other thing he wanted me to make sure I mentioned was it's about a third. He finds that in Sykeston, it's about a third extra to do those type of projects. And those go directly to the ratepayers in that city.
Okay. All right. Any questions? Seeing none, thank you for your testimony. How many other people in support? I'll be the last.
I'm the last.
You're the last.
Thank you very much, Mr. Chairman. Bob Jackson, City Utilities, Springfield, Missouri. We go on record in support of Senator Sater's bill. We have a gas, water, electric, and in Springfield, we operate our own power plants. And as Mr. Lawson said, we have people on staff that can do that. One of our power plants goes back to 1960. We have people in Springfield that can do it. We are customer owned. Municipal utilities are customer owned, and these costs could eventually drive up rates for our consumers.
Any questions? All right. Any questions of the witness? Say that. Thank you for your testimony. All right, opposition. How many do I have an opposition? All right, folks. We got about 12 minutes. So figure out how to make your points. But we're going to be down here at 3 o'clock. So I apologize, but I think some of it will be about the same as it was maybe before the other 3 days.
It will be the same Dan Weinster, Opinion Decorating Foundation, Wall Ceiling Contractors in St. Louis. Same objections that I voiced earlier. The only one I would say to my dear senator next door, when he says that, just doing painting and things like that. I don't know what happens when the guys start painting and all of a sudden they get lead and asbestos. Do they have the training? Do they have the certification to handle those issues? I doubt it. Thank you.
Dennis Corrigan.
I'm sorry. Questions of the witness? Seeing none, thank you.
Dennis Corrigan Company, St. Louis. I just want to make a comment about the senator saying that some of these contractors refuse to participate in this process. We're playing by the rules. Reporting hours is not burdensome. Maybe the prevailing wage in certain areas is this desired lesser wage rate. But if nobody reports the hours, how can you determine apples and apples? Somebody mentioned throw the baby out with the bathwater. I think, if these laws are going to be amended, reporting requirements should be a big part of it. Thank you.
Questions of the witness? Say none, thank you for your testimony.
Hi, Denise Hasty here with the Agency of Missouri. The agency is opposed to Senate Bill 606, believing that the change in definitions is really problematic. As written, the definition of maintenance would allow a public entity to pay less than prevailing wage on projects to install a concrete or asphalt overlay over an existing gravel road, no matter how long or how big that project is or how short. For that matter, they could tuck point an entire building or paint the entire exterior of the building and it would be called maintenance. And that's because maintenance also allows in this definition for improvements to the facility as long as they don't cost more than the original cost of the facility. So we respectfully oppose this Senate bill.
All right, questions of the witness? Seeing none, thank you for your testimony. Next.
Tim Leasky, Davies Contracting. I was too verbose earlier, so I'm just expressing my opposition.
All right, thank you. Questions of the witness? Seeing none, thank you. Anyone else opposition?
The Chemical Contractors Association of Eastern District in Kansas City.
Questions of the witness? Seeing none, thank you. Next. The next in line.
Mark Dalton, again with the St. Louis Kansas City Carpenters Regional Council, going on record as opposing the bill. It is not clear. It stated earlier that maybe some of the local contractors do not want to participate in the process of the prevailing wage gap, which is kind of still wondering about that and why they wouldn't, if it's a concern of being paid too much for the job, or why they wouldn't, if it's a paperwork, or kind of what the reasoning is behind some of them not wanting to participate. But Yeah, prevailing wage does not limit anyone from participating in the project.
Questions with, seeing none, take the testimony. Next.
Mr. Chairman, Nancy Gibbons representing Construction Employers Coalition and also Terry Briggs with Site Improvement Association have to go to another hearing, so I'll turn it in this form as well.
You're doing double duty.
Got it.
Questions with, seeing none, take the testimony. Next.
Chairman, Adam Brown, Laborers, once again, we're glad of demons in the source, we're here to support our industry.
You probably better say your name a little quicker to the phone, who you're with, on the microphone. Just make sure they get it for the record. Just say your name and who you're with again.
Adam McBride, representing the Laborers Union.
All right, any questions with us? Say that, thank you. Anyone else, opposition? Anyone, informational purposes only? Senator?
Mr. Chairman, thank you for letting me present this. You know, there are a lot of small contractors, and where you live and where I live, it's just two birds. They can't, you know, do what they're supposed to do with prevailing wage. But also in your, what is your, I've handed out from the city of Hollister, they gave permission for me to have this in the committee. And it shows the difference between this one project and the small contract. The difference in price. Thank you very much.
All right, thank you for bringing that bill forward. That concludes the hearing on insurance small business. Thank you.